Good morning, everyone. I'm David Goodis. I'm Assistant Commissioner at the Information and Privacy Commission of Ontario. Welcome to the first of our new online webinar series. We have apparently over 300 people participating today, which is fantastic. So the goal of this new series is to engage with people on the important issues they face under Ontario's access and privacy laws. Today's focus, of course, is situation tables. A situation table, we think of it as involving representatives from the government, from service agencies, and from the health sector, meeting regularly to identify and address situations that raise concern about the safety of individuals. The main goal of a situation table is to collaborate on intervention strategies that will lower the risk of harm. And of course, this often requires the discussion of highly sensitive personal information. So in the next hour, we're going to review the IPC's recommended information sharing roadmap for reducing harm while respecting individual privacy. You should know that we developed our roadmap after a lot of thought, a lot of discussion, and extensive engagement with stakeholders. So I'll tell you a little bit about some of our background with situation tables going back a few years. So a few years ago, we had started to hear about issues that had arisen at situation tables from municipalities, particularly in Ottawa and Toronto, for example. As a result of that, we decided to participate in various forums to discuss these issues and try to assist people in managing compliance with privacy legislation. So starting with in 2013, we participated in the Ontario Law Reform Commission workshop on integrated approaches to community safety. A year later, 2014, we participated in the Waterloo Region Crime Prevention Council and their dialogue on privacy and information sharing. In 2015, we participated in the Canadian Economics of Policing workshop that was held in Ottawa. In addition to that, we've also actually attended, observed, and commented on various situation tables throughout Ontario, including in Cambridge, in North Bay, and in Rexdale. Even more than that, we did work very closely with the Ministry of Community Safety and Correctional Services as they developed their guidance document for situation tables in Ontario. And they've produced their document called Information Sharing in Multi-Sectoral Risk Intervention Models. And we also assisted the OPP in the development of their similar guidance document. So I'll let you know that today's main presenter is Stephen McCammon, who's to my immediate left. He's legal counsel with the IPC. I should also mention that we have with us today Manuela DeRay, who's our Director of Legal Services. So we're going to play for you Stephen's presentation, which is pre-recorded. It's essentially a PowerPoint presentation with Stephen's voiceover. So that's about 15 minutes. And following that presentation, we're going to come back to you live, the three of us, and we're going to take your questions and do our best to answer your questions. This entire presentation, including Stephen's presentation, is going to be available to you on our website, and other resources that we're going to refer to today will be available to you. So please feel free to submit your questions on the on-screen dialog box that you should see in front of you as you watch the presentation. So don't wait until the end. Please get your questions in sort of as soon as you can, but we'll compile those and we will respond to them when we come back. Your questions will be read anonymously, and other participants will not actually see your questions as you write them. So please keep in mind that we do have a lot of people with us today, so we may not be able to get to all of your questions. So it's best, as I said, to submit your most important questions as early as you can. So we are now going to begin Stephen's presentation, and we will see you back in about 15 minutes.
Welcome to the IPC's webinar on situation tables. A growing number of government institutions, social service agencies, and health sector professionals are participating in, or considering participating in, situation tables. When members of a situation table meet, personal information may be shared to help reduce harm, sometimes without the individual's consent. While this may help to ensure safer communities, it comes with risks to personal privacy. The broader the disclosure of personal information, for example, disclosing an individual's name to the entire table, the greater the risk of a privacy breach. As such, all participants must approach the sharing of personal information diligently and with caution. The sharing of personal information must be done in a privacy-protective manner that complies with the Freedom of Information and Protection of Privacy Act, the Municipal Freedom of Information and Protection of Privacy Act, and, in the case of personal health information, the Personal Health Information Protection Act. For the sake of simplicity, I will just use the phrase personal information and the terms situation table member or agency from here on in. Each agency involved in a situation table must have legal authority for its information handling practices, including its decisions to collect, retain, use, or disclose personal information. This is why a privacy-protective information sharing roadmap is essential. If, for any reason, you are considering not using the recommended roadmap, we urge you to pause and conduct a Privacy Impact Assessment, or PIA. A PIA is an organizational risk management tool used to identify the effects of a given process or activity on personal privacy. Guidelines on how to conduct a PIA and a PIA tool are available on our website. But let's get back to the roadmap already developed in collaboration with the Ministry of Community Safety and Correctional Services. The recommended information sharing roadmap begins with a strong governance framework to ensure that all situation table members participate in a privacy-protective manner. A solid framework includes an information sharing agreement signed by the participating agencies. This agreement should confirm who may collect, retain, use, and disclose personal information, under what circumstances, and for what purpose. It also should outline the measures taken to protect personal information. Situation table members also require policies outlining 1. Steps to help ensure that information is accurate and up to date. 2. How individuals can request access to and correction of their information. 3. Rules regarding the secure retention, transfer, and disposal of personal information. 4. Training and auditing procedures. And 5. Transparency requirements. Once you have the necessary governance and planning in place, the first thing to remember is that data minimization is essential to compliance with privacy requirements. At every stage, it is important to ensure that those handling personal information have the legal authority to do so. In short, the collection, retention, use, and disclosure of personal information should be on a need-to-know basis only. This includes ensuring that each situation table member has a legitimate need to know the identifying information before that information is shared with them. However, long before you get to the point of sharing an individual's information at a situation table, remember, it is a best practice to first try and obtain the individual's consent. For example, if a service provider believes an individual, let's call her Jennifer, is at an elevated risk of harm and would benefit from the services of other agencies, it is best to ask Jennifer for her consent to share her personal information at the situation table. In obtaining this consent, Jennifer would need to be informed of what specific information would be shared, which agencies would receive her information, and for what purpose. Jennifer might agree to disclose personal information to some agencies, for example, to health and education agencies, but not to others, for example, to police or children's aid societies. To the extent that disclosure relies on her consent, the restrictions she asks for must be respected. If Jennifer consents to the disclosure of her personal information, the agency that obtained her consent should document the date, scope, and details of her consent. Sometimes, however, it may not be possible to obtain an individual's consent or to obtain sufficient consent. In these circumstances, if the disclosing agency still believes that non-consensual disclosure is required, situation table members will turn to the four-filter approach. Let's say you have a client, Henry, who is not responding to offers of service, but you have reason to believe that he poses a significant risk of serious harm to himself or others. How can you help reduce the risk of harm and still be compliant with Ontario's privacy laws? Let's look at the discussion that must take place before Henry's information may be shared with other agencies. As outlined in the Ministry's Guidance on Information Sharing in Multi-Sectorial Risk Intervention Models, a four-filter approach is recommended for information sharing. This approach is comprised of the following steps. Filter 1, an agency's initial screening process. Filter 2, a de-identified discussion with partner agencies to assess the risk factors. Filter 3, a de-identified discussion to identify who can receive identifying information. And Filter 4, a full discussion among intervening agencies only. During the initial screening process, the agency considering whether to bring Henry's case forward to the table uses relevant personal information it has in its possession to help determine whether Henry is at significant risk of serious harm and if the involvement of other agencies is required. The second step in the four-filter approach requires that the disclosing agency begin by only sharing de-identified information about Henry at the situation table. What is de-identified information? De-identified information is information that has been stripped of Henry's personal information and therefore cannot reasonably be used on its own or in combination with other available information to re-identify him. In some cases, the removal of direct identifiers like name and contact information may not be enough. Unless they are also removed or masked, quasi-identifiers may be used to re-identify Henry. Quasi-identifiers might include information revealing, for example, Henry's gender, postal code, marital status, family information, location, date of previous incidents, diagnosis, ethnic origin, or profession. In each case, you must carefully assess which quasi-identifiers could potentially lead to identifying Henry, while zeroing in on the key risk factors that you will need to discuss in order to mitigate harm. The best way to reduce the risk of re-identification, while ensuring that the table is able to identify and assess cases involving significant risks of serious harm, is to avoid any discussion of irrelevant details and to ensure that relevant details are not discussed in unnecessarily precise terms. For example, it will rarely be necessary to share the individual's precise age or address before Filter 4. Instead, assuming that either of these characteristics is important, at Filters 2 and 3, Irrelevant details can be masked by discussing them in terms of general neighborhood and a relevant age range. For example, minor, under 25, or senior. If, by the end of the Filter 2 discussion, the harm thresholds have been met, the third step is to identify the agencies reasonably believed to be necessary to the planning and implementation of the intervention. Further review of the risk factors in a de-identified question and answer driven discussion will help reveal which agencies need to be involved. For example, if it appears that the risk factors are tied to issues associated with housing and education, it would make sense to consider whether agencies that provide housing, shelter, and educational services should be involved at Filter 4. At this point, identifying information such as the name and address of the individual, may be shared, but only with the identified subgroup of agencies. In other words, only those agencies reasonably believed to be necessary to the planning and implementation of the intervention may remain for the Filter 4 part of the meeting, where they will first learn the identity of the individual. The Filter 4 meeting should be held separately, well out of earshot of the other situation table participants. In addition, the discussion should be limited to the information reasonably believed to be necessary to help plan and implement the intervention. Note that if, during the Filter 4 meeting, individual agency representatives of this subgroup decide to perform a lookup on their respective systems, any further information sharing must also comply with data minimization requirements. Of course, if the initial Filter 4 discussion reveals that another agency should be involved at Filter 4, at this point, that agency can be brought in on the discussion right then and there. During the intervention, consent should drive any further information sharing. This consent should be sought at the first reasonable opportunity. If the individual declines the offer of service, further sharing of personal information should cease. At a later meeting of the situation table, during the report back stage, unless the individual has expressly consented to being identified to the entire group, the report back to the table should be strictly limited to de-identified information that reflects, for example, the individual in case number 1XA was connected with services, declined further service, or that the intervening agencies need to discuss further action. Two more issues bear comment before I wrap up: record keeping and notice. At situation tables, the agency that brings the individual case forward, as well as the planning and intervening agencies, may need to record some information about the case, including some personal information. However, newly assigned unique pseudo-anonymous numbers should be used to keep track of individual cases at the situation table, rather than identifying or quasi-identifying information such as an individual's initials, address, or telephone number. Any other notes captured by any of the other agencies should be securely destroyed, particularly any notes that may contain personal information. As a general rule, individuals should receive written notice that their personal information was disclosed. The notice should include contact information for each agency to whom disclosure was made. Alternatively, the notice could include a contact number or website that would allow an individual to readily access that contact information, as well as ask any other questions. Written notice may be provided by, for example, the lead agency during the first in-person intervention, using a card, letter, or pamphlet. Note that if, at any stage, it becomes evident that the risks are already being mitigated, for example, the individual is already connected to sufficient services, no further information sharing should occur. However, the individual should still receive notice of any disclosure of their personal information from the disclosing agency. Such notice should also reveal the names of the agencies to which disclosure was made and where to obtain further information. The situation table model is an important part of the growing emphasis given to harm reduction in Ontario. Harm reduction is, of course, a laudable goal. At the same time, participating agencies must comply with privacy requirements and be accountable to individuals and the public about their participation in these tables. Situation tables can operate in a privacy-protective manner with sufficient planning and governance. We know this from our experience. The use of the Privacy Protective Information Sharing Roadmap will help you to handle personal information in compliance with privacy legislation. If you are unable to resolve governance and planning issues through your own internal resources, the IPC is available to provide institutions and health information custodians with general guidance on the necessary privacy protective governance framework for your situation table. Thank you very much.
Okay, welcome back, everyone. I hope you enjoyed recorded Stephen, because now you're going to get live Stephen. And I'm going to turn it over to Manuela, who's going to manage some of the questions that we've received. And all three of us will address those. Manuela?
So the first question we received is, can you briefly discuss how the guidance about information sharing at situation tables could be used by hospitals to guide information sharing outside the situation table, for example, in disclosing information to non-health information custodians, particularly police? So I'll take the liberty of answering that question. I think the information sharing guidance that we've produced really is meant to address situation tables where you not only have health information and non-health information custodians, but also other institutions who may be subject to FIPPA or MFIPPA. So it's really a meld of three different privacy legislations with one lens, one privacy lens. If you are going to, as a hospital, be sharing information with police, I would direct you instead to the Personal Health Information Protection Act. And basically that act says that you either need express consent or the disclosure has to be permitted by the health privacy legislation. Three examples where you can disclose information to police would be under Section 40, where there's a significant risk of serious bodily harm, to a person conducting, under 43(1)G, to a person conducting an investigation, inspection, or similar proceeding authorized by warrant or by an act where the information is necessary for that purpose, or three, where required or permitted by another law. So I would direct you to PHIPPA and its framework for sharing information directly with police outside of a situation table context. The second question is, the presentation mentions training and auditing. Can you expand on the auditing process? Stephen?
Thanks, that's a great question. So I think we take a practical approach here and recognize that auditing means different things in different contexts depending on the sophistication of the parties, their resources, and the records and issues they're faced with. At the situation table, auditing could involve something as simple as having a sample of the de-identified records reflecting cases that were sent on to Filter 4, reviewed for lessons learned. It could also involve a periodic discussion at the table reflecting on what's working, what's not working, and why, both in terms of potentially over-sharing at the table during discussions, as well as undersharing that led to delay or difficulty in identifying and acting on cases, appropriate cases for risk intervention.
So the third question is, has the IPC received complaints from anyone who has been the focus of an intervention where prior consent was not obtained and the filter for process was not used?
We had a number of inquiries, expressions of concern about situation tables over the last few years. For a number of reasons, none of those have led to a privacy investigation. Perhaps first and foremost because it was the Commissioner's decision to understand the situation table practices first, dialogue with stakeholders, and develop useful privacy guidance in that collaborative format and that manner. I think one other important piece to understand here is that many cases the situation table, the individual intervened at through a situation table would not, until new disclosure practices come online, have an understanding that their personal information or personal health information was disclosed to the whole table. It's only now, as the provincial guidance and the guidance from the Information Privacy Commissioner's Office is coming out, that situation table participants are understanding that when they disclose personal information at a situation table, they'll be going on to let the individual know of that disclosure. With the discipline approach we've mapped out for you, that should reduce the likelihood of any complaints or concerns, but certainly individuals will now be in a position to know that their personal information was disclosed and to raise those concerns directly with members of the situation table if that's the case.
So the next question is, how do we judge reasonably believed if we don't know what an agency has in its records? So what the fear is, are we going to miss something?
Right.
Steve, how do you respond to those concerns?
Sure. I think the first point is that the discussion that leads to the design of who will be at the filter 4 part of the meeting, where the identity will be learned, that filter 3 discussion is a rigorous question and answer discussion. It happens in a de-identified fashion, but it really helps to tease out what are the risk factors that are at play in the case presented by the disclosing agency. And if the participants at that table can engage in a thoughtful and rigorous discussion, they're going to have a pretty good idea of the main presenting risks, and that will of course lead to some links between the kinds of risks that have come to light and the kinds of agencies at the table that can be involved in planning and implementing an intervention with respect to those risks. The next point is that the discussion moves on to the filter 4 separate part of the meeting, and that's attended by those initial subgroup of agencies it's reasonably believed are going to have a role to play in planning and implementing the intervention. Those members of the group will now have a further discussion in which more information, in fact personal information, identifiable information will be revealed amongst that subgroup. They're going to develop through that process and possibly through a lookup of their individual systems. At that point, they're going to develop an even more granular picture of the individual's case, the risk factors at play, who else they might have been involved with, and that discussion may lead to a decision to pause that meeting, go back out to the group, grab a couple or one more other agency and bring them into discussion. And again, a richer picture emerges. Lastly, I would say that the situation table is not, of course, an answer to all problems. The interventions will themselves lead to a better understanding of the client and their needs, and consent from that individual can lead to more detailed picture of their risks, and involvement of other agencies is needed.
I think this is a common theme because I see that of number of the questions we've received can be summarized into this question. Did the presentation just say that the name and address of the individual is disclosed at filter 4 after the necessary agencies are identified? And then I'm going to meld it with another person's question, which says, we run the risk of missing out on important information. For example, if there's no known history of violence or weapons in an earlier filter presentation. The police may not be involved. So how do they, first of all, did we say that only the name and the address should be divulged at filter 4? I think the answer is yes.
Yeah, the answer to that question is yes. I think it's also important to bear in mind that the test, if you will, for identifying the subgroups is one of reasonable belief. It's not a test of perfection, nor are people being asked to put masking tape over their mouths and not to discuss concerns about safety. I suspect that in a number of cases there'll be some indication that there might reasonably be thought to be a public safety concern associated with a particular kind of intervention. And so questions about involving the police in filter 4 are not, it's not going to be a rare case perhaps that it's reasonable to think about bringing police to filter 4. I think there has to be a thoughtfulness about it, but it's not a standard of perfection. It's a standard of reasonable belief. And so as that thoughtful and more detailed discussion occurs at filter 4, well ahead of the actual intervention, if there are legitimate concerns about safety, of course police can be brought to that part of the meeting, and they may indeed bring out more information that says police should be at that intervention, and that would still be compliant with the legislation.
And have we ever audited any situation tables for their use of personal information? Maybe you wanted to explain some of our involvement in some of the situation tables and what our role was there in order to gather the information necessary to help us provide this guidance here today.
Good question. Certainly we sent staff from our policy department out to spend a full day with 3 situation tables, get a real sense of how those discussions were unfolding, how they were working from a privacy point of view, and how they were crossing the line. After that, we have engaged multiple discussions with situation table stakeholders, including hearing their concerns about the filter 3 and filter 4 stages of the process. And at the end of the day, the evidence before us has been that this can work with a thoughtful and rigorous discussion particularly, as I said, at the filter 4 stage.
The one question we've had is, do we know of, or can we point to an existing document that can be provided to an individual who is the subject of a discussion at a situation table that explains the situation table function and has space to list the partners to whom the information has been disclosed? Are you aware of any such template?
It's also a helpful question. I know one of the things we signaled in our presentations and in the pre-recorded section of this event, these are really this is on the edge of a planning and governance issue that we may be able to provide more granular guidance on going forward. We have a number of inquiries from municipalities and a number of areas of Ontario right now on the issue of communicating the notice of disclosure, and we'll be coming forward with some information about that. I think the early sense is that like with the auditing piece, we want this to be practical and doable. So for example, if you have an existing pamphlet that illustrates the function of your situation table and lists your regular members, one possibility is to insert some brief language in that pamphlet that explains that personal information has been disclosed to entities that are ticked off on the form, and provides the form pamphlet would also provide information about where to go with further questions. That might be one possible route, but as I indicated, we'll be coming forward with something more concrete than this oral presentation provides now, and look forward to sharing it with the situation table of practice that might be one way to get it out to the community here in Ontario.
So one of the questions was, this individual hasn't really ever heard of the term situation table, and was wondering whether it would include civilians subject to no laws. For example, if you're talking about a child, their parent, or their family member.
I'm not sure if that was meant to refer to the family member or parent being on the situation table as opposed to communicated with or having personal information disclosed to. But let me back up by saying that we know that situation tables are convening with institutions, public entities, departments and municipalities, for example, health information custodians, as well as, I'll refer to them as NGOs, non-governmental organizations, who are regular attendees at situation tables. And the guidance we provided is mindful of that range of actors being at the table. That's one reason we suggest and strongly encourage that situation tables develop an information sharing agreement, because some of those entities are not regulated under Ontario privacy legislation, or perhaps under any privacy legislation, a number of NGOs, for example. And so the information sharing agreement becomes not only a disciplining tool, but also a tool that's helpful to those NGOs, so that they know what the rules are and can bring themselves into line with those practices and provide them with confidence that their participation in the table will be compliant with privacy principles and as well as any privacy requirements. And as for disclosing personal information to family members, I think there the question would largely come down to whether or not that disclosure was reasonably believed to be necessary for the purposes of reducing or eliminating a significant risk of serious bodily harm. And there might be cases where it would be appropriate to involve a family member in order to help reduce that kind of harm.
So there is a comment that from someone, and maybe we need to dissect this in a few pieces.
Sure.
So the direction from the IPC is to request consent for further disclosure if the initial disclosure was done under the authority of the risk-based provisions in FIPA and FIPA or PHIPA, and suggests no further information should be shared if consent is refused. If the situation continues to present a risk of serious bodily harm, does the intervention need to stop if consent is not provided?
So certainly the communication from situation table stakeholders, and some of our guidance has worked with their approaches, including their moderating approaches. The ministry has set out guidelines that provide additional moderating, one could say privacy protective approaches that aren't themselves required under privacy legislation. Here too, I think this call for non-disclosure after a person declines service is both rational in terms of privacy requirements, but also rational in terms of the dynamics and the imperatives of the situation table, which are to respect the individual's right to decline service. And at that point, certainly the general principle is to stop the sharing of personal information at the situation table. That's not to say that one of the intervening agencies, now apprised of a significant risk of serious bodily harm, has no duties or authority to continue to pursue that case as an individual agency. And that might apply to more than one agency that set the intervention. But insofar as we're talking about information sharing back at the situation table, I think the point is you have to stop and start again if you're going to disclose further personal information.
And if I could take this to the health context, for example, there's the consent-based provisions in PHIPA, so you can disclose with consent. And if you don't have that consent, or someone refuses that consent, but there is authority to disclose that information without consent, for example, under Section 40 to prevent a significant risk of serious bodily harm, or to a person conducting an investigation under either a warrant or under a law, that information can then still be disclosed as you as an individual organization or entity. So I think we need to distinguish between information sharing at a situation table versus what are your responsibilities and duties and obligations and rights, in fact, under your enabling legislation.
Apart from the situation
Apart
table.
from the situation table. So the next question is, there are occasions where if one informs a person that their information was disclosed at a situation table, the timing and manner of that disclosure may raise a risk of harm to the individual or others even further. So how can this be managed with privacy legislation as it pertains to disclosure? And let me take a first stab at this, because I have some intimate experiences with this question. And in health privacy or legislation, for example, there's a duty to notify the individual if their information was stolen, lost, or subject to unauthorized access. And the arguments or the comments we get from the health sector are, oh, well, we can't disclose because there's this individual may harm themselves further, knowing that their information has been compromised. And what I see in response to that is there is a spectrum of when, and there's a spectrum of manner of disclosure. And no one-size-fits-all method of notification or communication with an individual is appropriate in every circumstance. And so you need to think about, well, do I need to tell this person, for example, the next time we have a meeting, as opposed to calling them on the telephone and having a cold call? Do I tell them now, or do I wait till the moment of elevated risk has passed? The health sector deals with this all the time when they have to deal with breach notification, and I think some of the experiences from there, it teaches us that no one size fits all, and that's why it's notification at the first reasonable opportunity. Stephen, do you have anything?
I think that's a great answer. I think our guidance thus far, in terms of some of the slide decks and other materials we've provided, has hit the high water mark, which is the notion of as soon as reasonably possible. But Manuel has done a great job of bringing us down into the assessment of what that means and the allowance for reasonable concerns about elevating risk rather than reducing it by rushing a notice. It's helpful comments.
So a question is, are students permitted to participate at situation tables when accompanied by the involved agency? And I'll take the first stab at answering, and then you could. So if an agency brings a student to a situation table, for example, to learn or for their own educational advancement, you are responsible for the actions of that student. Therefore, you better make sure that that student is aware of their duties and responsibilities, and that you have either an agreement with the school who sends you students, because this is not just about students at a situation table. This is students in every day-to-day work that you do, and in being involved in having access to confidential or personal information. So you have to ensure that that student understands their duties and obligations, and that what their obligations are with respect to using it, making further disclosures of that information, etc. So you need to be careful to ensure that anyone you bring to a situation table is appropriately trained and understands their duties and responsibilities. Mm-hmm. Stephen?
Yeah, just to add in on that we've advised that if consent were the basis for authority to disclose, one element of that would be to inform the individual which agencies will receive that information. We didn't suggest that the individual needs to know the specific name of the agency representative. So insofar as your student is there, as Manuel has indicated, as one of the representatives of the agency, and they're superintended and trained to respect the privacy concerns alive at a situation table, you'd be in compliance with the framework.
So another question is, if we undershare information to only a few hand-picked agencies, we may leave the client at risk. Are there clear parameters on how to determine relevant agencies at filter 3?
Yeah. So the parameters have to emerge from your experience and expertise in addressing risk. I mean, participants at a situation table are from agencies that already have, and from personnel that already have working experience serving clients, identifying their concerns and trying to marry those concerns to relevant service. So I think the situation table model as a whole relies on the dedication and passion of the community of people who are participating at situation tables from the get-go. This framework simply leverages that expertise and experience, as well as the process that a table undergoes in the agencies coming to know each other, developing trust with each other, developing a better understanding of what kinds of work and what kind of risk factors the different agencies in fact deliver. I've heard in a number of situation table meetings, members say one of the greatest things that happens at a situation table is that the different agencies really start working together in a whole new way that allows them to better understand what the different agencies are doing, what they're bringing to the table in terms of their capacity to help mitigate risk. So I think all of those elements lead to a context in which experts are able to get at the key issues. And as I said before, they're able to get that in an iterative process that allows for the initial subgroup to be expanded as the discussion at Filter 4 continues, and possibly expanded or contracted as the intervention itself is delivered. So there's an iterative process, and I think the call is to have confidence in that process and to work it, including through the auditing processes, and the review discussions that will help indicate what works and what doesn't work.
I'm going to meld, there's been maybe a half a dozen questions relating to this topic, so I'm going to meld it to talk about record keeping after a situation table. Mm-hmm. So when should a record be kept of the discussion at a situation table? Where should the record be kept? And if it's requested by the individual, should access be provided?
Mm-hmm. So we've said that the key actors in terms of keeping records, particularly of personal information, fall into two categories. The first is, of course, the disclosing agency itself. That's the agency that from the get-go knows the identity of the individual and has thought to bring their case forward to the table in a de-identified manner. And the second class of agencies that would keep records, including records of personal information, would be the agencies that attend the Filter 4 meeting, either at the get-go or as it evolves, as they too would have the identifying information about the individual and would be responsible for thinking through and delivering the intervention. So that's where the record keeping would go on in a fashion that identifies the individual. Now, we also understand that it's useful for situation tables to keep track of cases in a de-identified fashion. In the presentation I spoke of it in terms of case 1XA, so that there is an overarching record on how many situations were brought to the table, how many made it to Filter 4, how many didn't, and further evaluation and tracking can be done based on an analysis of the de-identified data, including through some of the databases that are being created around those de-identified data sets. I think the last part of your question, if I'm not right, was access. And certainly the right of access is a right that individuals have under both PHIPAA, with respect to personal health information, and in respect of personal information under FIPA and MFIPA. The records will be found, of course, in those entities I just mentioned, the disclosing agency and the planning and implementing agencies. Whichever one they fall in, that act would apply and the right of access would live there. There are exceptions to the right of access to one's own personal health information or health information, but the general rule is you have a right of access. And each information custodian in those two classes would be responsible for receiving and answering those access requests and complying with the legislation, completely consistent with the legislation.
And in the health sector, you will be subject to your own duties and obligations, for example, under the Public Hospitals Act, or if you're a healthcare provider, for example, under the Nursing Act or the Medicine Act, and therefore you are required to keep records, either pursuant to that statute or pursuant to the requirements of your college. And as Stephen indicated, patients would have a right of access to that information, subject to any exceptions or exclusions set out in PHIPAA. So the next question is, I thought it was name, date of birth, and address at Filter 4.
Yeah, I don't think we spoke exhaustively on precisely what data elements would be used at Filter 4 to further the discussion and further the consideration of personal information. I think date of birth might very well be one of the pieces of information used or disclosed at Filter 4, particularly to the extent that the Filter 4 subgroup is going to do a lookup on their own systems. They're going to want to get to the right individual, and date of birth can sometimes help to do that. The key point, however, is that the discussion at Filter 4 should involve the disclosure of all the personal information that's necessary to plan and implement an intervention, and no more than that information. And so date of birth might very well work in that context as a necessary and acceptable element for disclosure.
So I think what Stephen's trying to say is that, again, date of birth may be relevant or may not be relevant. It depends on the specific circumstances of this case. If you're trying to indicate that, there's a senior, I mean, I don't think you need to know that the senior was born in 1929. The guy's between 60 and 70. The guy's over 70. There's a child. There's a teenage child. It depends on the context. That's all I'm saying is, sometimes you need to know the precise date of birth for a certain reason, maybe to look up on a system or something. But I think we need to be cognizant of, that level of detail. Stephen?
Yeah, I just think that sensibility you just offered is particularly relevant during Filter 2 and Filter 3, where you're not disclosing, you're not supposed to, you're not trying to disclose the identity of the individual. You might need to share information about someone's age in a range because that age is relevant to an assessment of risk and to identify youth service agencies as opposed to senior service agencies. The date of birth might become more relevant at Filter 4, where you're needing to make sure that you now look at, if you're doing a lookup, and you're able to get to the specific individual, not someone else who happens to share that name. That's the utility of the date of birth at Filter 4, I would suggest.
There's been also a number of questions about guidelines for sharing of information in a state of emergency or emergency circumstances, ice storms. A number of these kinds of questions have come through, and they've asked, is there any guidance available through our office? And yes, the short answer is yes. It's not information sharing at a situation table, but we do have guidance available on our website. And it's called something about disclosure in the case of emergency or urgent circumstances or something like that. It's available on our website, and it deals with various scenarios, and it pans PHIPAA, FIPA, and MFIPA. And a corollary question was, well, what piece of legislation applies in that kind of state of emergency? And while I'm not, I'm not aware of all the pieces of legislation that may apply in a state of emergency. Depends on the actor. They may be subject to different privacy legislation. If you're dealing with, for example, a local emergency response or emergency management and planning division of, for example, a regional municipality, they would be subject to MFIPA. If you're dealing with the provincial government to coordinate emergency response, then you would have FIPA applying if you're trying to coordinate also with a hospital or a public health unit. Then you may have FIPA as well as MFIPA as well as PHIPA apply. So there, you know, and just because we're in a state of emergency, one legislation is not kind of the be-all and end-all, but there may be another piece of legislation that may provide further support to information sharing in those states of emergency. Stephen?
This reminds me of our first question that takes us outside of the focus of our work on situation tables. An important area, I do know that there's a duty to disclose personal information in cases of grave environmental harm, I believe is one of the elements of the test under FIPA and MFIPA. But yeah, perhaps one thing will happen here today is we'll get a sense of key issues for future webinars.
Mm-hmm. So how do you go about notifying an individual if the current contact information of the individual is unknown?
Fair question. I suppose that goes to how do you conduct an intervention writ large. You need to reach the person in order to intervene as a general rule. So I think that it's an important question, but it certainly goes to the heart of delivering this work. If you can't get to them for the intervention, how are you going to get to them for the disclosure notification? Fair question. Just a general comment. Our statute, again, allows for, in the context of the duty to notify, best efforts to reach them as soon as possible. And that, of course, builds in the possibility they're going to have some challenges, but figuring out where they are. But you must make best efforts to do so.
Okay, this is going to be the last question because we're nearing the end of the hour. So, what are the recommendations when an individual makes a complaint about disclosure to an identified agency after they've been notified of this intervention? Do all agencies have to be involved? Does each agency have to deal with this in terms of their privacy breach protocol? If I can...
Sure. Yeah.
So this is one of the reasons Stevens has indicated that you should have policies in place to deal with what happens in the event of a privacy breach, what happens in the event of a privacy complaint, who's going to deal with the complaint? Is it going to be the person who initially brought the client forward? Is it going to be the agency or agencies who have intervened in the person's life? This happens all the time in the health sector when there's a breach involving multiple databases or a shared repository. You need to develop a protocol that sets out some of these, the way you guys are going to dance with one another.
And just quickly, it may also be something that these become lessons learned for your auditing and review in terms of, you know, was this a straight up privacy problem? Was this sensitivity in the way that the intervention went forward? So lessons to be learned there.
Okay, thank you both. We come to the end of our time. Thank you everyone for joining us. We do have more questions that we received. Unfortunately, we didn't have time to get to them all, but do know that you can contact us at any time through our general contact email or telephone, so we can try to manage or answer your questions that way. So thank you again for joining us, and we look forward to seeing you at our next webinar. Bye, everybody.